Okay, I got a young guy trying to overturn a wrongful conviction. He got hurt, just got some settlement money, and decided he was going to hire him a lawyer. So I explained to him about the rules, professional conduct, etc., that he should read that before speaking with his lawyer. We'll get into that in a minute. Anyways, I told him the quickest route, because he's looking for case sightings and discrepancies going on through the trial. And I told him just start at the beginning, the very beginning. What was supposed to happen at the very beginning didn't, which is in the rules of professional conduct and the code of judicial conduct, which gives him ineffective assistance of counsel, prosecutorial misconduct, and judicial misconduct. So I told him the easiest approach, and this is a surefire, because he didn't get a quick and speedy trial. He said he asked for one, but he doesn't know the limitations on a quick and speedy trial. So just being denied or not having access to a quick and speedy trial is his way out. Okay, so listen up. In Georgia, a speedy trial is a constitutional right governed by specific states' statutes. OCGA 17-7-170 requires a state to bring a defendant to trial within strict court-defined deadlines. If the state fails to do so, the charges must be dismissed. Okay, how the process works. Statutory demand: you or your attorney must file a formal written demand titled "Demand for a Speedy Trial" with the clerk of the court. It must be served to the prosecutor and the judge. I can guarantee your lawyer didn't bring that up, young man in Georgia over there, that he must file a formal written demand. The young man said they had no evidence. It's all based on hearsay. And they prolonged the proceedings to try to get him to cop out. And he did. He eventually did. They kept throwing on more and more charges, which violated the double jeopardy clause. You cannot prosecute or convict somebody multiple times for the same crime, which is the third part of the double jeopardy clause. So I told him they can't do that, but he didn't know that, and they use that as a scare tactic to get him to take a plea deal. If you don't take the plea deal, we're going to add more charges, you're going to get more time. Then they come, he says no, so they said okay. They came back later. If you don't take this plea deal, we're going to give you more charges and more time. He said no, so they gave more charges and more time. So they came back again. If you don't take this one, we're going to give you more charges and more time. So he fell under the pressure and took a cop out. But basically, it was just hearsay, his word against her word. The preponderance of evidence wasn't there. Totally innocent until proven guilty. Wasn't in effect. But there were so many things that were supposed to happen didn't happen. Okay, so the attorney didn't file a formal or written demand. And neither did he, well, because he didn't know. He said he did ask, but it didn't happen. So remember, there's a timeline. It says right there, a timeline. Okay, the government has 2 terms of the court for 3 terms. Once filed, the government has 2 terms of the court or 3 terms for capital cases like murder, armed robbery to try the case. Terms of the court. Court terms may vary by county and jurisdiction, but they are typically quarterly, e.g. January, April, July. Okay, key rules of consideration. Timing. The demand must be filed during the court term when the indictment or accusation is filed, or during the very next term. Readiness. The defense must have jurors impaneled and present, and the defendant must be in court and explicitly announce they are ready for trial. Failing to do so waives the demand. Constitutional speedy trial. Becker versus Wingo. If the statutory window does not apply, you can still claim a constitutional violation based on balancing tests that evaluates the length of the delay, the reason of the delay, and the harm caused to the defendant. Because of filing for a speedy trial can be a major legal gamble. Sometimes pursuing your trial before your lawyer is fully prepared or ending plea negotiations with the prosecutors, highly recommended consult with local attorney regarding your specific case. If you are facing an active charge, let me know. Okay, so like I said, this kid said there was no evidence. It didn't happen. He wasn't there. He was sure nothing was going to happen because he had no knowledge or wasn't anywhere in the vicinity. So he was denied a quick and speedy trial. Okay? Where are the guidelines? Demand for a quick and speedy trial in Georgia. There's a lot time limit. I think 90 days if you're incarcerated, if you're locked up, and 120 days if you're out on bond. Okay, so he was. So I told him you can file an IAC, Ineffective Assistance of Counsel petition, and it's easy to prove ineffective assistance of counsel. By the way, the lawyer not mentioning it to him, that's misconduct, okay? And remember, reporting professional misconduct, that's mandatory. So the state's attorney and the judge were supposed to report his lawyer for ineffective assistance of counsel, but they didn't because reporting is mandatory. Okay, so it would have been competence. Oh, this is Illinois. I wanted Georgia. Okay, here we go into the rules. Okay, would have been competent, rule point 1, diligent to communicate, 1.4, this quick and speedy trial thing, okay? And if they didn't get him to a quick and speedy trial within a limited time, that his case would be dismissed. Okay, I would be diligent to communicate that. You have meritorious claims and contentions for his failure to expedite that litigation. You want to be there's supposed to be candor toward the tribunal. There was none. How about the state's attorney fairness to the opposing party by bringing this up and making sure you got a quick and speedy trial that would show impartiality and decorum to the tribunal? Remember, special responsibilities of the prosecutor, you're supposed to be honest and trustworthy and not bring any case, that has no probable cause, but you do it anyways, okay, people? So there's a lot of things he can mention there. Truthfulness statements to others. There was no truthfulness statements made to him in person, personally. So dealing with unrepresented person when they first approached him. Lack of representation, and they were demanding that he take a plea deal. I think that's what was with the police. Responsibility of managers, so he had assistant state's attorney going on, but still the state's attorney is responsible. communications concerning a lawyer's service. He didn't communicate any of this to you, okay? This is a mandatory service, this is his job description, his or hers. So remember, reporting professional misconduct is mandatory. It says right here, reporting professional misconduct, Rule 8.3. You open it up, and it says it's mandatory, okay? A lawyer having knowledge that another lawyer has committed a violation of Georgia rules of professional conduct raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects should inform the appropriate professional authority. A lawyer having knowledge judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office and should inform the appropriate authority. So this guy was telling me, the rules are different in Georgia. I'm in Illinois. I said no, because they're all based on the model rules of professional conduct. You can find that on the ABA website, American Bar Association. And those, the rules and the codes there, those are for all courts, all lawyers and judges. Each state uses them, and they may change the verbiage because they add things to it. But basically they're all the same. So reporting requirements, restrictions on filing disciplinary complaints. Okay. Let's see what it says there. Lawyers shall not enter an agreement containing a condition that prohibits, restricts a person from filing disciplinary complaint or that requires a person to request dismissal of a pending disciplinary complaint. The maximum penalty for a violation of this rule is disbarment. Okay? Multiple violations. It's impossible just to violate one rule. You violate one, you violate multiple rules, as I mentioned earlier. It would have been competent to communicate, the quick and speedy trial. A finding of a third or subsequent disciplinary infraction under these rules shall, and in itself, constitute discriminatory grounds for suspension or disbarment. A special master and state disciplinary review board may exercise the discretionary power when the question is appropriate before them. Okay, so like I said, it's impossible to violate just one rule. The conviction of a crime, suspension, or disbarment. Remember, violating the rules of professional conduct, that's deprivation of rights. They took the oath to do this. They are required. This is what is behind the oath. Not just the oath of office the oath attorneys take or judges take, but the oath of public service. Okay. So when they took the oath to serve and protect you. So these are all your rights. These are laws here. So these are musts. These are, they have to do it. And if they don't, they're breaking the law. Conduct constituting threat or harm to clients or public emergency suspension. Refusal to failure or to appear for a reprimand. This is a lot longer than Illinois'. Okay. Okay, so unauthorized practice, membership in legal law reform activities affecting clients' interests. We went over that. Reporting professional misconduct, disciplinary authority, choice. Disciplinary authority. A lawyer admitted to the practice of this jurisdiction is subject to disciplinary authority of this jurisdiction and regardless of the lawyer's conduct occurs a domestic or foreign lawyer is also subject to disciplinary authority. Jurisdiction of domestic or foreign lawyer provides an offer to provide legal services. Jurisdiction of lawyer, domestic foreign lawyer may be subject to disciplinary authority or both of this jurisdiction and another jurisdiction for the same conduct. Okay. Okay, but you're going to want to go over the rules. I have helped people in many different states, and I've been in many different courts in Illinois, helping people in Illinois, and doing things for myself, and I have yet to see, every time I pull the rules out in the codes, things change drastically. Okay, so he's gonna, that's ineffective assistance of counsel. Okay, so, but remember, these laws also apply to the opposing party. So remember, when it comes to, the quick and speedy trial, your lawyer may say, well, hey, I didn't get this from the opposing party or that. Well, in fairness to the opposing party, expediting litigation would be diligent, it would be competent. So, I mean, no matter who you're talking to or about, and even the judge, remember, these are the legal obligations of all lawyers and judges. They are to see to it that it happens and watch each other like a hawk to make sure everybody does this, and who doesn't, that's a go to jail. That's federal crime. That's deprivation of rights under the color of law. Okay, so you want to go over the rules, and I was going over this. Okay, so that was a quick and speedy trial. That didn't happen. Disinformation. So he was fed disinformation about the quick and speedy trial, and they say, well, they didn't lie to him about it. When he asked for it, it didn't happen. So not saying anything is still disinformation, okay? Over here, about the IAC motion, ineffective assistance of counsel motion in Georgia, typically refers to ineffective assistance of counsel claim in criminal case. To win this, you must prove both that your attorney's performance fell below objective professional standards using the rules of professional conduct, and that's quite easy. And you don't even need evidence. You just need the rules and the codes. And that error changed the outcome of your case, showing prejudice, bias. Your own lawyer will, if your lawyer isn't going over the rules with you, they're not working for you, they're working for themselves. Okay, you can try a post-conviction process. You can typically raise an IAC claim on your direct appeal. If your attorney is still representing you, a new appellate counsel must raise it in a motion for a new trial or through the state habeas corpus petition to build a factual. So you can use a state habeas corpus petition as well, okay? And it all depends on what you say, and we're going to get to that. The Strickland standards, you must satisfy the U.S. Supreme Court's two-pronged Strickland versus Washington test. You need to show that your lawyer made errors so serious that they were not function as the counsel guaranteed by the Sixth Amendment. And you not having a quick and speedy trial, nobody mentioning it to you, that's enough. And that's multiple violations of the rules of professional conduct. That's ineffective assistance of counsel. You need to show that your lawyer made errors. Okay, guaranteed by the Sixth Amendment. You're guaranteed effective assistance of counsel in the Sixth Amendment, and that's set forth in the rules and the codes. Okay, and define performance, prejudice your defense. Preserving evidence, the burden of proof. That's what I told him about. I kept trying to tell him, but he kept talking over me. the burden of proof wasn't there. The state proved nothing. It came down to hearsay, his word against her word. The burden of proof is heavily on the defense. You will likely need to schedule an evidentiary hearing to question your former trial lawyer about their strategic choices and lack thereof. And all you got to do is go over the rules. Go over the preamble. Oh, you're going to love the preamble. I forgot about reading that. Okay, let's go back there real quick. Because, I mean, they don't do this. It's just crazy. Oh, okay, come on. This thing's taking too long. Cheap generic phone. A lawyer is a representative of clients, an officer of the legal system, and a citizen having special responsibility for the quality of justice. As representative of clients, a lawyer performs various functions. As an advisor, a lawyer provides the client with informed understanding of a client's legal rights and obligations and explaining their practical implications. As an advocate, a lawyer zealously asserts that client's position, quick and speedy trial, under the rules of the advisory system. As a negotiator, the lawyer seeks results advantageous to the client but consistent with the requirements of honest dealings with others. An intermediary between clients, a lawyer seeks to reconcile their divergent interests as an advisor and, to a limited extent, as a spokesman for each client. A lawyer acts as an evaluator by examining a client's legal affairs and reporting about them to the client or to others. 3. Professional functions. A lawyer should be competent, prompt, and diligent. Okay, so there's professional procrastination is forbidden. A lawyer should maintain communication with the client concerning representation. A lawyer should keep in confidence information relating to representation of a client, except as far as disclosure is required or permitted by the rules or any other law. A lawyer should use law's procedure only for legitimate purpose and not to harass or intimidate others. A lawyer should demonstrate respect for the law, the legal system, and those who serve it, including judges, lawyers, and professional public officials. While it's a lawyer's including judges, other lawyers, and public officials, the legal system, and for those who serve it, including judges, other lawyers, and public officials. While it's a lawyer's duty, when necessary, to challenge the rectitude of official action, it is also a lawyer's duty to uphold the legal process. A citizen lawyer should seek improvement of the law, the administration of justice, and the quality of service rendered by the legal profession. As a member of the learned profession, a lawyer should cultivate knowledge of law beyond its use for clients, employ that knowledge in reform of the law, and work to strengthen legal education. A lawyer should be mindful of deficiency in the administration of justice and the fact that the poor and sometimes persons who are not poor cannot afford adequate legal representation, and therefore devote professional time and civic influence in their behalf. A lawyer should aid the legal profession in pursuing these objectives and should help the bar regulate itself in the public interest. The we the people. A lawyer's professional responsibilities described in the Georgia Rules of Professional Conduct as well as substantive and procedural law. A lawyer also guided by conscience and provision of professional peers. A lawyer should strive to retain highest level of skill to improve the law and legal profession and exemplify the legal profession's ideals of public service. I told you, people, all lawyers are public servants, okay? It says so in the preamble here. In the nature of the law practice, conflicting responsibilities are encountered. So let's go over it again. Legal profession exemplify the legal profession ideals of public service. All lawyers are legally required to do what's in the public service, what's in the public interest to maintain the public trust. In the nature of law practice, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from conflict among attorneys' responsibilities, clients, the legal system, and the lawyer's own interests remaining of an upright person. The Georgia Rules of Professional Conduct prescribe terms resolving such conflicts. With the framework of these rules, many difficult issues of professional discretion can arise. Such issues may be resolved through the exercise of sensitive professional and moral judgment guided by the basic principles underlying these rules. The legal profession is largely self-governed, although professions also have been granted powers of self-government. Legal profession is unique in the respect because of this close relationship between the profession, the process of government, and law enforcement. The connection is manifold. In fact, that ultimately authority over legal profession is vested in the Supreme Court of Georgia. To the extent lawyers meet the obligation of the professional calling, the occasion of government regulation is obviated. Self-regulation also helps maintain the legal profession independent from government domination. An independent legal profession is important for us preserving government under law. For abuse of legal authority is more readily challenged by profession whose members are not dependent on government for the right to practice. 11. The profession's relative autonomy carries it with special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived of the public interest and not in furtherance. I don't know, it won't go up for it. And it says, are conceived in the public interest and not in furtherance of the bar or parochial interest. But for some reason, this won't go up. There's a couple more lines there. Well, either way, you'll want to get into the preamble besides the rules, scope and representation, allocation of authority. And this is a lot of ammunition you could use against your lawyer to prove ineffective assistance of counsel, use against the opposing party. Lawyers shall abide by the client's decisions concerning the scope of representation as required by Rule 1.4. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as the plea to be entered, whether to waive a jury trial or whether the client will testify. A lawyer's representation, including representation by appointment, does not constitute an endorsement of the client's political, economic, or moral views. A lawyer may limit the scope of objectives of the representation if limitation is reasonable under circumstances. The client gives informed consent. See, people, it even says it here, informed consent. In order to give informed consent, you need reasonable knowledge to make an informed decision. To give that informed consent with knowing what I'm going through would be a portion of being able to give that informed consent. I would consider this reasonable knowledge. A lawyer shall not either knowingly or willfully blind his counsel client to engage in criminal fraudulent conduct, nor knowingly with willful blindness client with such conduct. Okay, so there's a lot of stuff you're going to have to go over that nobody is doing. Diligence, communication, fees, let's see. Oh, so here it is. Client with a diminished capacity. You can claim yourself client with a diminished capacity because you lack the ability to give informed consent, because you lack the reasonable knowledge, the legal knowledge, to make an informed decision to give informed consent. When a client's capacity to make adequately consider decisions in connection with the representation is diminished, whether because of minority mental impairment or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client relationship with the client. When a lawyer reasonably believes that the client has diminished capacity, and that is your ignorance of the law. They take advantage of that. They will tell you in a court of law, your ignorance of the law is not a valid defense. We'll use that against them because these people are legally supposed to be held to a higher standard. And there's no standard whatsoever that they're holding each other to. You want accountability? Remember, not doing this is deprivation of rights, and that's not just against your lawyer, but the opposing party and the judge, and nobody reported misconduct, which creates conspiracy against rights under the cover of law. which is a federal crime. Meritorious claims and contentions. You have meritorious claims and contentions because none of this happened. Okay, candid towards I'm serious. You're going to really want to get into all this because none of that's happening. And then the code of judicial conduct you're going to want to use as well. Okay. Where is it? Let me see. To petition the Supreme Court of Georgia to review a lower case, attorneys typically file a petition, a writ of censure within 20 days of a court appeals for a denial motion or a reconsideration. This requires showing that the issue of great gravity of public importance. Okay, that's all in what you say, okay? And I threw together a bunch of laws. Okay, let's go over here. And I'm quite sure you'll understand once I read it to you. Just a bunch of laws I threw together. I told this kid, see, I just read the Georgia rules of professional conduct, and I did this using the Illinois rules of professional conduct. And I told them they were the
Giving
same.
illegal orders.
They're constructed based off the model rules of professional conduct by the ABA. Okay, I put here a combination of quite a few laws to make it make sense. Don't blame me that nobody lives up to the oath or any job descriptions required by the oath. Violation of the oath alone is deprivation of rights. Nobody being prosecuted for violating the oath clearly shows a conspiracy against rights under the color of law. Look it up. It's on the net. Okay, ignorance of law is not a valid defense. Holding me to a higher standard than you hold yourself. The malice in law, the presumption of guilt prevails. Okay, look that up, the malice in law. That means they broke the law to hurt you, to make you look like a bad person. The presumption of guilt prevails. It's supposed to be the presumption of innocence, but you know the moment somebody points a finger, the moment somebody points, makes an accusation, the presumption of guilt is there. And they care less about the preponderance of evidence. Okay, so this kid was saying he made a plea, he took a plea deal. But whether it was a plea deal or proceedings, I put the plea deal was made under duress due to disinformation. That's lawyers and judges lied to him, which is illegal. Lack of disclosure. Look up disclosure law. The lack of informed consent. Look up informed consent. Informed consent requires reasonable knowledge to make an informed decision and give informed consent. It would have been competent, that's Rule 1.1, diligent, Rule 1.3, and candid, Rule 3.3, to communicate, Rule 1.4, to advise, Rule 2.1, to be fair, Rule 3.4, and show impartiality and decorum, Rule 3.5, with truthfulness, Rule 4.1, and divulge the rules of professional conduct and the code of judicial conduct, the legal obligations of all lawyers and judges to maintain the requirements of disclosure. That's deprivation of rights, as reporting misconduct is mandatory in both the rules of professional conduct, Rule 8.3, and the Code of Judicial Conduct, Canon 2, Rule 215. No one, not counsel for the defense, the opposing party, nor the judge reported each other or themselves for misconduct, which is misconduct, which should have happened at the very start, didn't, creating a conspiracy against rights under the color of law. Okay, those are a bunch of laws. In the public interest, look it up, it's on the net. In the interest of justice, look it up, it's on the net. Justice must be served. Your oath requires it. First and foremost, holding a layman, pro se litigants, to the legal requirements, the expertise of a legal learned professional refutes the very principle of a fair trial. Clearly in the interest of the bar, not in the public interest, thus under the color of law. Look up under the color of law. That's abuse of power. That's highly unethical and violates the rule of law. This shows bias holding a layman to standards you have yet to hold yourself or others in the legal profession. And it clearly shows a conspiracy against rights under the color of law, or add to it if my motion is denied. Statute of limitations cannot apply to those who lack the reasonable knowledge, legal knowledge, to make an informed decision or give informed consent. The lack of disclosure from the very beginning created this constitutional crisis, which suggests the court's effectiveness was limited, and why. I reiterate, in the public interest, in the interest of justice, justice must be served. Your oath requires it. This was a conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance of counsel, and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional and the code of judicial conduct. Failure to report misconduct is misconduct, as is failure to enforce one's constitutional duties as prescribed in the rules and codes. The lack of the requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which show due process didn't exist. A deprivation of rights in its entirety. It clearly shows the judge and attorneys in my case committed a conspiracy against rights under the color of law. 18 U.S.C. 242 prohibits the willful deprivation of rights, which privileges and immunities under the color of law. 18 U.S.C. 241 prohibits conspiracy to injure, oppress, threaten, or intimidate any person in the free exercise and enjoyment of any right or privileges secured by the Constitution or laws of the United States. I trust you will live up to the oath and show, Rule 1.1, competence, diligence, in expediting litigation, as I have meritorious claims and contentions. I strongly stress reporting professional misconduct and maintaining the integrity of the profession. Communications will be made for, I trust communications will be made for ethical violations, and every penalty will be imposed. In the public interest as trustees, this is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. An interest of justice dismissal with prejudice is legal required, as is inciting the RICO Act. Pretty sure that made sense to you. It's just a bunch of laws I threw together, okay? You can look them all up. These over here, Rule 1.4, that's from the Rules of Professional Conduct. Okay, forms to fill out. Ineffective assistance of counsel motion, IAC motion, motion to quash, writ of habeas corpus, writ of certiorari. You can take that to your Supreme Court, State Supreme Court, or the U.S. Supreme Court, the writ of certiorari. Rules of Professional Conduct complaint form. You want to look that up and fill that out. Code of Judicial Conduct complaint form. Look that up, fill that out. Deprivation of Rights complaint form. A conspiracy against rights under the color of law complaint form. Ethics complaint form. Post-conviction whistleblower complaint form. Or on a late notice of appeal. And look, I gave you everything you might want to say there. Okay. I've been saying this for years. Different iterations, but basically came out to the same. Okay, so that's just a bunch of laws. This guy gets on my nerves. Chief Justice John Roberts is warning Americans to stop personal attacks on judges. He says it's got to stop. Roberts says criticizing court decision is fine, but going after judges themselves is dangerous. Which it is. I wouldn't do that. Use the law, people. Okay? Look at this knucklehead says the rule of law is in danger. Well, if people were charged charged properly, the penalties for violating the rule of law, if they were charged accordingly, nobody would be breaking the rule of law, especially in a court of law. Happens in every court of law. If they're not abiding by the rules and the codes, you're definitely violating the rule of law. You're holding yourself above the law. Now, I'll hold you to the letter of that, Chief Justice Roberts. I'll hold you to the letter on that in any court of law as you can me. Okay, people remember, they have to do this word for word to the letter, according to the letter of the law. You know what the penalties are for violating the letter of the law? Okay, this is how my page legal reform. Follow your emotions.